Hi, welcome to Mondays with Melissa. Today I want to talk a little bit about institutional Medicaid. So what we normally focus on is preparing the Medicaid application and asset protection planning. But I also want to talk a little bit about Medicaid exempt transfers. So one of the topics that we cover many times is what needs to be transferred out of someone's name to make them eligible. And we talk about the 5-year look back and all of the planning that needs to take place. But there are some transfers that are exempt, which means Medicaid is okay with them and they don't penalize the person for making those transfers. So one of those transfers is a transfer to a spouse. So a lot of people still don't know that you can transfer everything that you have to your spouse and be eligible for Medicaid in a nursing home the next day. But your spouse then is going to be sitting with larger amount of assets than they originally had. And so they may have to do something called spousal refusal, and there are other parts of the puzzle that go along with that. But when the first spouse gets sick, if there's a need for care immediately and planning hasn't been done, we always have the ability to transfer to the well spouse or the community spouse and get the first spouse on Medicaid without penalties. Another exempt transfer is a transfer to a disabled child. It's actually disabled, blind, or minor child. But what we see most often is transfers to a disabled child. Now, this can look different depending on the situation. You could have a child who's on Social Security disability because they maybe were injured at work, but they're not on any other government benefits. They're not receiving Medicaid themselves. They're not receiving any sort of supplemental security income. They're getting Social Security disability, which means they're allowed to have assets in their name. Now, you can transfer assets to a child who's on Social Security disability, and that's an exempt transfer for Medicaid purposes. The more difficult cases are when you have a child who's potentially developmentally disabled or disabled such that they're receiving government benefits themselves. So they're limited as to what they can have. And in those cases, if you're going to transfer assets to that child, you have to do it into a supplemental needs trust or a special needs trust. And that again can complicate the matter, especially if there are other children whom you ultimately want to inherit from your estate when you pass away. So that exemption is a little bit trickier. Another exemption, and one that we do take advantage of when we can, is something called a caretaker child exemption. And this is related only to your property, your real property, your primary residence. If you have a child who's been residing with you for at least 2 years prior to your need for a nursing home, you can transfer that home to that child without any Medicaid penalties at all. It's Medicaid's, way of saying, okay, you've been there for 2 years, likely caring for your parent and keeping them out of a nursing home. So we're not going to penalize the transfer of the house to you. So if there are other siblings or other kids, the house can only go to the caretaker child, and it has to be a child. It can't be a grandchild or a niece or anything like that. You have to provide the birth certificate and also proof that that's been the primary residence of the child for the prior 2 years. And we usually do that with tax returns of the child. So there are definitely exemptions that need to be looked at when we're applying for Medicaid. And when you sit down to work on a Medicaid application with an elder law attorney, they're really the ones making the legal recommendations. They're giving you legal advice, whether it's myself or another elder law attorney. That's really where you want to focus on working with an attorney who does this every single day and knows these types of nuances. Please remember to like, share, and subscribe, and we'll see you next week.